and at 9:03, and we will begin our workshop today. The purpose of the workshop is to go over policy 5.311, policy 5.331, policy 1.28, policy 1.30, and RSM Statement of Work Part 1. Then we have a good of the order and adjournment. And with that, I will turn it over to Ms. Dupree-Bruno.
Good morning, board members. Thank you, Madam Vice Chair. Today we're going to go through 4 policies. Originally, they were the Ethics and Education Policy 1.28. We have broken those policies down to 4 separate policies. Before we begin, I do want to thank the individuals who worked collaboratively to draft these policies to be able to bring it to the board today. Dr. Atkins, Dr. Pruitt, Mr. Brown, Mr. Rothenberg, and Attorney Williams. At this time, we'd like to go ahead and move forward with the proposed board policy 5.311, which is employee investigation and the discipline policy. Just as an overview, sections 1 through 4 of the policy discusses the process that is defined by the policy, the IRT, which is a review team that determines whether the complaint is legally sufficient. It discusses the investigation and the conduct during investigations, as well as ensuring that investigations are conducted by disinterested parties, as well as a conflict of interest screening so that anybody who's doing an investigation has no conflicts with the investigation or the parties involved in the investigation. Sections 5 through 6 of the policy talks about the particular investigators. Number 1, there's no adverse action for a good faith investigation. During the investigation, the investigators will gather documents, speak to witnesses, and conduct a thorough investigation. When there is a conflict of interest or upon the superintendent's recommendation, a referral will be made for an external investigation. If the complaint involves the superintendent, the school board attorney, or the internal auditor, by a majority vote of the school board, an external investigator will be appointed to conduct those investigations. If the complaint is with regards to a school board member, only local law enforcement or the government, federal or state, will be able to conduct those types of investigations. Sections 7 through 10 of the policy discusses the formal notice requirement that anyone undergoing an investigation will be properly notified. Anyone undergoing an investigation will have the right to due process, and the investigations will be conducted timely within 60 to 65 days. If there is no just cause, then a letter will be sent out to the party to advise them that there is no just cause for any further disciplinary action. During this process, an employee will have the right to have representation through the union, through an attorney of their choosing. Section 11 of the policy discusses what we call ORT Level 1. This is conducted after the investigation is completed, after the employee has had an opportunity to attend a predetermination hearing where they have an opportunity to provide their side of the story, as well as have an opportunity to provide a written response. After all of that is done, then it will be presented to the ORT Level 1 committee, who will then take in the information and make a determination. The ORT Level 1 includes representatives from Human Resources and District Administration and Legal Services. They will review and then make a recommendation to the superintendent. If the ORT Level 1 is unable to form a recommendation, it will then be sent to the ORT Level 2 committee. Upon approval, the superintendent can then adopt the ORT Level 1 recommendation if he so chooses. Section 12 through 14 discusses ORT Level 2. Can we go back one slide, please? Oh, can we go forward one slide, please? I'm sorry. Thank you. Section 12 through 14 is ORT Level 2. ORT Level 2 is triggered by a recommendation by the superintendent and is automatically referred if the disciplinary recommendation is termination. This committee is made up of odd-numbered committees, including executive directors, chiefs, and/or the school board attorney. This committee will then provide a recommendation to the superintendent. Section 15 through 17 discusses outcomes. Outcomes include letter of guidance, letter of reprimand, suspension, demotion, termination, other disciplinary measures such as training, and then the superintendent will make any other recommendations and the final decision as to the discipline that is required in a particular case. At this time, I would like to invite Dr. Pruitt and her team to discuss the the OPS investigation manual, and then Mr. Hudak will discuss the OCR process. Thank you, Dr. Pruitt.
Morning. Board members, superintendent, we're happy to be here this morning to review this information with you. And here to discuss and to answer questions are Mr. Brown, the Director of Professional Standards, Will Rothenberg, the Director of Compensation and Labor Relations, Fernando Vasquez, who's an investigator, and then Ryan Hudak from the Office of Civil Rights. And basically what we wanted to do this morning was you've had ample time to review the information and the proposed policies. What we've included with that is an HR manual and an Office of Civil Rights manual to further explain the processes and how we go about doing the work. It's closely aligned, including the Office of Civil Rights, because up until about a year ago, or maybe year and a half ago, that was part of the Professional Standards Department. And so we do still work very closely together, and that's why we're here this morning to answer those questions. Before we get to your questions, I just kind of want to review with you, Human Resources has worked really hard over the last 5 years to become a data-driven division. And as a result, I kind of wanted to share with you what are the metrics that we look at and have looked at for the last several years that are specific to this department. And the things that we look at in the Act Point KPI, where we compare ourselves through the greater city schools, we look at investigations per 1,000 employee, and then we look at grievances yearly and over a 5-year period. And we, in the school district of Lee County, are well below our peers relative to, any indicators or any issues. Our percentages are actually some of the lowest relative to the greater city schools. And then we further look at different metrics in relationship to different processes. For example, each year we evaluate, we look at the numbers of investigations, we look at the makeup of those individuals, and when I say makeup, we look at the employee units that they're from, we look at their, we look at race, we look at, all of those different things to see, do we have an indicator or some sense of concern relative to a particular group of employees, race of employees, et cetera. Again, those numbers are always consistent, and what I mean by that is the percentage, let's say, the percentage of white employees and the number that are investigated, it's consistent. So there is no statistical anomalies related to that those type of numbers. We also look at due process concerns, and we look at things that have gone to the state or that FEA has come back at us for, and I'm happy to say we've had 0 issues related to due process as they've come through any of our formalized processes. So that, that's a very good thing as well. About 50% of our cases have representation by the union, and none of those cases have resulted in any, due process concerns relative to the union. When you look at the number of grievances we have and you compare us either through ActPoint KPI or to our 15 to 16 sister districts, our numbers are extremely low compared to our counterparts. We attribute that a lot to our interest-based process that we utilize in this district, which allows us to kind of work through these things or kind of handle those things up front. So I kind of lay that groundwork to let you know that, because of the data-driven division that we are, that even in the area of professional standards, we dissect that data and we look at it to see, relative to, are there standouts relative to our metrics. That being said, and even though our metrics are all in a really good place, like I said, either well below or below what other comparing districts look like, we acknowledge that over, I want to say, the last year or so, starting with Weiss-Schroeder, there was, it was brought to our attention that this board had concerns about our process and concerns relative to some of the things, and so that's why we went to work on, revising this policy, also looking at it rather than having a single process document relative to investigations, that we expanded it to the manual that is being presented to you today. And when we tried to get down to the specifics of concern, one of the things that we were able to identify is that there was concern that it was the same people from the start of the process to the end of the process. And so as a result, as your school board attorney just shared in the overview, that has changed so that the people that are in the IRT, in other words, the intake, there are different people at the end of the process that are the outcome review team. And so, and that's specific to addressing what we were told are the concerns from Weiss-Schroeder and then from Ms. Dupé-Bruno when she came on board. So we just want to acknowledge that we heard you, and so we went to work on addressing those concerns. And really with that, I would just, on behalf of professional standards and the Office of Civil Rights, that will really be our presentation, if you will, and now we're just here to answer questions and address any other issues or what have you that the board might have.
Mrs. Gittens?
Good 10 minutes. I just wanted to say overall, thank you so much for listening and making adjustments, and I think we're on the way to an equitable process that will be good for everyone. The question I'll just ask you on the side, but otherwise, thank you so much for listening and making the changes.
And I apologize. The one other thing I did want to say is we did review all of this information with TALC, with SPALC. They sent it up to their attorney at FEA, and there is some attorney feedback but nothing that is, a substantial that would change anything we're doing, just more about, sort of acknowledging things. In other words, they're comfortable with what is being presented to you today.
Great, thank you. Ms. Jordan?
No, I was just trying to get you.
Oh, okay. Sorry. Mrs. Patrica?
So thank you, because that was one of my questions, was what has their involvement been? So I'm glad to hear that they've been engaged in the process. What would constitute a conflict of interest that would require an external investigation?
One scenario we would look at would be potentially if the employee maybe was a relative of somebody in professional standards, or if maybe they worked closely together. Those would be some indications that we would want to consider an outside investigator.
So having made the person's acquaintance at some point, or having worked in the same department, or knowing of them or knowing them, that's not a conflict?
No.
Because that would probably make a lot of
Right, and I will,
investigations external.
right, and I will say to you that if somebody raises that concern, we discuss it, and, you know, even to the point where we may consult with the superintendent if we feel there's a concern, or if somebody raises a concern, and definitely always consulting somebody in legal services to get that opinion as well.
Okay, and then, so does this mean that the board can no longer direct the superintendent to, and the one that's freshest in my mind right now is the cheerleading investigation? We directed the superintendent, I believe, maybe we didn't direct you, but you decided to go with an internal investigation, an external investigation on that one. Assuming there is no conflict, does this policy prevent that kind of expenditure of funds?
Ms. Patrica, it will be up to, the superintendent still can decide whether or not he wants to have an external investigation.
Okay.
He can still make that recommendation.
Okay, and can the,
And that's what was done in that case. It wasn't, I don't recall you directing me to do that. We did that because of some of the reasons actually Dr. Pruitt just indicated, because we had people that were levying allegations against the very group that would be investigating them clear on up, and we felt the only way that we were going to be able to provide the board with what you felt was an objective opinion at the time was to get an external investigator. I don't agree with that because I think you would have gotten an objective opinion. However, having stated that, I believe that for the purposes of transparency, that's the way that we chose to go.
okay, thank you. My last question, and then my last question for you, Dr. Pruitt, and then I have a question for you, Dr. Atkins. There are clearly some costs associated with this as we bring together review committees. They're going to have to, it's man hours. We're going to be expending man hours, additional man hours to go through these processes. What are the projections, the budget projections for the additional costs, and where will we get that money?
Thank you for that question. I will say to you that right now, because we have been utilizing this new process for a couple months now, it really, I don't see it as an associated cost at this point, even though, as you say, we're bringing people together. I have found, and I think my team here would agree with me, that it really has led to some very good and robust discussion, and also has, you know, changed some outcomes relative to that. So I see this as a very positive change, and one that, given the way we've been doing it the last 2 months, wouldn't result in additional costs. Where I would see that might be an issue would either be around using outside investigators and or, you know, something that might be associated with you know, the hotline and how the calls come in. Those are the two areas that I see there could be a cost concern.
And then Dr. Atkins, can you just, you know, provide your advice from your seat as to how you see this process playing out, whether you see concerns in it, just what's your opinion?
Well, my opinion is that, you know, I think when we started down this journey, one of the things that we talked about with each board member was just the desire that the process itself appear objective on its face, so that anybody, whether, you know, if it's the employee being investigated or somebody who was raised a concern that was being investigated, felt that they were getting an objective, fair handling of their situation. And so what this process does is gives the opportunity for a second review of the case by an outside, and I don't mean outside the district, but objective parties that have no direct involvement. And also the other piece is that these cases sometimes, if they don't get resolved at this level, go to another level, like a DOA, you know, Department of Administrative Hearing, or an arbitration where you do have an external judge or arbitrator that is going to decide the case. And so if you already have an objective external person to the investigation reviewing this, I think it makes the case even more robust and defensible.
Thank you.
Thank you. Thank you, Dr. Pruitt.
Madam Chair, I will just add that.
Sorry.
As having been involved in some of these ORT Level 2 reviews, I would just concur with Dr. Pruitt and what Dr. Atkins has said, that the process seems to be a very, very good process and has led to robust discussions and sometimes just thinking a little bit more broadly. So I think it's been working so far over the last 2 months. So again, my appreciation to Dr. Pruitt and her team, OPS, and Dr. Atkins and Mr. Williams for bringing this forward. At this time, I would like board direction as to whether or not we should move proposed policy 5.311 to the formal rulemaking process.
Okay, before you proceed, I think Mrs. Giovanelli had a question.
So, actually, thank you. I know there's been a lot of work being done. These are very in-depth policies. So one of the questions I have is regarding the data. You mentioned the data earlier. So the data of cases that have been settled versus the retention rate. Have we been able to, in the past, with your data, the outcome?
Say more about what you mean.
Well, the outcome of, you were talking about data, when you've had investigations, does it usually lead to a settlement, or are we retaining the teacher or the staff, or what are the employee? Are we retaining them? I was just curious because I think it's important that teacher retention is very important. So that's my concern regarding investigations.
Yeah, I don't have with me this morning, if what I think you're asking me is from any case that we intake, what are the outcome, like 10% are resign or 15%? Yeah, I mean, we do, obviously, yes. I mean, teacher retention is really important, but that isn't the decision piece. The decision piece is the facts itself within the case and how, how it plays out relative to the facts.
Okay. I've not witnessed a lot of that, though, so that's why I'm questioning that. So,
could you clarify what you mean by that, so I can?
There's been numerous cases that the investigation didn't warrant the outcome sometimes. So, it's really important that the investigation is thorough, and so I like the second review process. So I'm very pleased with that. Because I think it's important that that one person or a handful of people are not the investigator, the judge, and the jury. So I think it's really important that that piece has been changed. So it's important. One of the questions I do have, though, the board can still direct the superintendent for an outside investigation. That authority has not been eliminated, correct?
The board has the authority to speak to the superintendent and make recommendations, make requests, and then between the board's directives and the board's conversation, I think the superintendent can make a decision as to whether or not he wants to move forward with an investigation, an external investigation.
But if the board directs the superintendent, then...
If there's a majority vote by the board directing the superintendent, that's one thing.
Thank you.
Great, thank you. Ms. Patrica.
Oh, Ms. Giovanelli's questions were so good, I forgot what I was going to ask.
Okay.
Oh, I remember. Attorney Dupree-Bruno, I'd like to reiterate my request to you for some training surrounding this process for us as board members. At what point does a complaint or an allegation that comes into the board become a document that is not subject to a public records request, that's confidential? Like, how should we conduct ourselves from the moment an investigation starts to the moment the recommendation comes before the board? And then during that meeting, what can we as a board consider? I'd love that training if you wouldn't mind.
Yes, I know that you requested a memorandum, and we'll have a training on that. I will say that during an investigation, these documents are confidential during the investigation, so I would remind the board of that. But we will have some more training in terms of from the time a case comes in to whether or not when it comes to you for a hearing. We'll discuss that.
Great, thank you.
Yeah, because, and I will say, thank you for that. The nature of the work that is done in professional standards is going to create a situation where when you're hearing from these folks, I would caution a couple things, and that is sometimes they're not always telling you the whole story, and nor can we. And so while it may give you a certain perception because you can only hear their side of the story, I just caution that, you know, they're generally a disgruntled person, and so, you know, because they're in the middle of an investigation, and just caution that, like I always said when, you know, when I was a principal about, you know, I won't believe everything that your child says about you if you don't believe everything your child says about the teacher. It's that same kind of thing. I always say, assume good intent, because again, you know, they're generally not in their best state of mind when they're calling or communicating with you. And so generally, you know, it's a Steve Harvey. There's the rest of the story.
Thank you. Ms. Gittens?
Just one quick question. Since you've been using this process for the last couple of months, have you noticed that it has helped to complete these cases in a more timely manner? Does it flow faster and get it, you know, get things done quicker? Or?
I would say not, only because when you look at our metrics relative to start to finish of investigations, we're well below the requirement and what the average is. Again, what you're going to hear about are the anomalies, and generally that has nothing to do with my staff. That has to do with either an outside attorney, has to do with you know, FEA and what they're doing, or has to do, you know, or law enforcement might be involved. But our metrics are really good relative to timeliness. So I would say, if anything, maybe just a little bit longer because of sometimes scheduling an ORT level 2. You know, may extend it about a week or so. So that would be my gut reaction to that question.
And thank you. And in response to Ms. Patrica's comment, I would really like to have that training as well, because doing that in the public would allow the public to understand better what this process is. And I think when people understand and see how it works, it makes it easier for everyone all around. Thank you.
I just have one question. So do you think that this process has any impact on potential litigation? I mean, do you think we'll have a decrease in lawsuits because we're using a more comprehensive investigation process?
It would seem like it, but it's really too early to tell. Again, when you look at our numbers overall, they're extremely low. So it's kind of hard when you're, you know, it's like when you're in A school and keeping the A school, you know, it's kind of hard to really get at that, because like I said, our metrics are really good compared to greater city schools and compared to our 16 sister districts. But I think there's always benefit in more review and more dialogue. I don't think there's harm in that at all.
Thank you.
I do want to reiterate that the intention of the Office of Civil Rights and Equity, run by Attorney Hudak, really is intent on reducing the number of OCR complaints, as an example. Their intention in that department is to really follow the civil rights process, the complaint process, and use those forms, and therefore, if it ever does escalate beyond, we've already done the preliminary work, you know, I believe. So I do think in the long run, although again, just like what's being indicated in human resources, I believe in that area, if you really look at school districts across the country compared to where we are, I think we fare quite well, particularly if you start to roll out some of the ones that are just sitting there because the OCR has not taken any action on them for years and years and years, which inflates our number, because this is something that, you know, should have been handled because of their backlog that hasn't been. If you look at really what's been filed in a recent period of time, the numbers are extremely low, but still we aim to reduce those even further through this office.
Thank you. Ms. Vaughn?
Yes, thank you. Excuse me. there's been an ask for board training, but my question is, what about training for the employees? What is it that, I'm thinking especially for our SPALC employees. We have a lot of SPALC employees that speak English but don't speak English well and may not understand these higher level contracts. And I know that and maybe when we get to the whistleblower, that might be, I'm glad we're meshing these things. But I really think that a lot of the employees will not understand, and what kind of guarantees do we have that going into these, that the employees, if they need a translator, that there'll be a translator there, because I know I've been told, well, that person speaks English, but what needs to be understand is there are a lot of people that speak conversational English, but not on the level of these contracts. So that's my question. What guarantees do we have that our employees will understand their rights?
So what I'll say to you about that is relative to the SPALC union, even though not everyone is a member per se, they do represent all SPALC employees. And now, not this year, because this year's been a little different, but in the past, they've had rep meetings where we've specifically gone over the contract, and we've gone over specifically the discipline process and how that works. And then those building reps are the folks that are there to assist the members within the school sites. But let's say that's not in place, or maybe there's not a rep that is as good as in another building. In the Office of Professional Standards, we have, folks that are bilingual within that office, but they will in turn, recommend, if necessary, to that employee to reach out to somebody else if necessary. Or we will sometimes advocate and, contact the union and get some advice. So I don't know about guarantee, because I think with anything we can provide all the information, but if,
Well, I'm not as worried about people that are at the school site. What I was thinking more were our transportation workers, our maintenance workers, and I'm sorry, I beg to differ on the union. I know the union negotiates the contracts, but like most of the rest of my colleagues, I have monthly meetings with the union. And the head of SPALC, I know, I have heard, is that person a union member? No. Sorry, you're not a union member. So there's not all those guarantees. And I would like to see translators provided for those that do not speak that higher level of English.
Yes, ma'am. With respect to our process and the formal investigative process and due process that Ms. Dupuy-Bruno spoke about, we do enlist professional translators as appropriate, and we utilize ones that are certified through the court system. And Mr. Williams has recently enlisted a comprehensive program that gives us access to translation services across the district in various contexts. I think some of them may apply for some of the kinds of things you're talking about, but in our process, where appropriate, we make that available to the employee.
Well, I'm glad to see that's happening now, because I know it hasn't always happened.
Ms.
That's all I
Giovanelli.
wanted to say.
I'm sorry, Mrs. Vaughn. Ms. Vaughn, were you finished?
Yeah, that's all.
Thank you. Mrs. Giovanelli.
So actually, Ms. Patrica brought up a really good question regarding the outside investigations. So yes, we did have that one. We've had a couple actually, but the one regarding the cheer, the recommendation from the outside investigator, the attorney out of Orlando made a recommendation, but yet we didn't follow that exact recommendation because she said it was a club and to treat it as such. But we're still not doing that at this point in time. So, when we do these outside investigations, are we going to follow the recommendation? Because I actually know one of the administrators recommended that as well and agreed with the outcome, yet that process was not, that recommendation was not followed. So are we going, I mean, when we spend the money for that, something like that, are we not going to take the recommendation that was recommended?
Well, I think in the case of this particular one, I mean, the first recommendation that we're looking for is how to proceed from in terms of what you're looking at in the investigation. So in the case of this investigation, did the actions of the school, were they fair and unbiased, and is there any remedy necessary as a result of that recommendation? So I think the outcome is what I was predominantly looking for. Yes, that in that particular case, I think the attorney did make a recommendation regarding clubs, and I do know that, that Mr. LaRosa, certainly look at how we are implementing cheerleading across the district, and I think we do or will have changes in how we implement cheerleading moving forward, such as how do we conduct these judges of these events. Now, COVID has kind of put a curveball in all of this, as you know. I mean, I think some of the things that we would like to do, we've been more focused on this, but yeah, I mean, I think if anytime you get an outside person who's going to look at something, you're going to certainly take that in consideration.
Yeah, I mean, I think it's important because when we spend that kind of money, we need to, there's a reason to do that. So we have to listen to the recommendation. Unfortunately, there's still issues with that whole process because Cypress Lake is having to redo cheerleading tryouts this year. So there's still some issues that really need to be looked at with that whole situation, and I'll just leave it at that. But I think it's important to note that.
Thank you. Ms. Gittens.
Thank you. Just quickly in response to Ms. Vaughn's question and your answer, in a higher overview of it, we as the employer, do we not have a duty to inform and educate all of our employees, whether union or not, of our process? And I understand when you say that, the union and the reps and all of that, but doesn't it really fall on us as the employer to educate and to inform?
Absolutely, and it is our expectation that is done through administrators, through department directors, through school principals. They are the front line for that employee, so we provide district leadership with the appropriate information, and then we kind of use this approach to help, because to your point, just because we put the information out there doesn't necessarily mean we're answering everybody's questions. So our expectation is that we inform the administrators enough so that they are equipped to answer those questions, and or that they know who they're supposed to contact if there is a question that cannot be, that they can't answer, that the employee has.
And I get that. I think as it continues to filter down, it also can have the possibility of being watered down. So my thought was, how we do insurance updates once a year or whatever, couldn't we do some, town hall type things for employees in the same way, and saying, here's the change, here's what it means to you, just like we do with insurance?
Yeah, I mean, with the insurance, we try to use that same model where we sort of empower. There's a rep at each school that is supposed to be the information expert, and then we help facilitate that. But and again, same model. So yes, I would say yes.
And if there was just an online thing that they could watch in their own language and have it available so that they understand, and then provide questions.
Yeah, thank you. That's a good suggestion.
Thank you.
Great, thank you. Ms. Jordan.
Yes. I wanted to say thank you very much for putting all this work in and doing this. And I will say too, as Ms. Vaughn had said, we do speak with the union at our meetings, and they have always said to me that they have a great relationship with the Office of Professional Standards and a good understanding of what has taken place. So I really appreciate that. And it's and then with Ms. Gittens asking about putting that information out, I think that's great, but they also have to The employees also need to be responsible for, once it's out there, if we can get that out there, and taking the time to educate themselves as well, because I know we all do that as individuals. You know, if there's something that we need to know, we try to educate ourselves on those issues. So thank you for bringing that up, Ms. Gittens and Ms. Vaughn. And just thank you very much for all the work.
Oh, Ms. Vaughn?
Yeah, I'm just going to add in response to what Ms. Jordan said. You know, we're all sitting up here, professional people, but we have to be aware and respectful that many of our employees don't have the same wherewithal. They haven't had maybe the same opportunities. And it's easy to say it's there and they should be aware of it. But I can guarantee, having taught ESOL classes, that the unfortunate truth is that's not going to happen. And I can tell you that the reading level on these contracts and even the manuals will be above the understanding. And I agree with Mrs. Gittens that it falls on us. It behooves us as a school district to put it into simpler terms if necessary, to make it widely available in Spanish and probably in Creole as well. And, you know, it's just us showing that we respect all our employees, that administrators aren't in a special class, that our bus drivers are just as important to this school district in getting our kids to school safely as any of the rest of us. So
Yes, relative
I just
to,
wanted to
yeah,
emphasize
to
that.
transportation, there is a whole separate labor management process and a whole separate safe driver plan, and that is all, to your point, relative to, the varying needs of the level of understanding of the employees, and that structure is in place in transportation. But I appreciate the suggestion relative to maybe some videos or something like that. The good news is, with 12,000 plus employees, we have less than 0.5% that are ever in a situation to need anything. So that's the good news. I know we're focused on that conversation this morning, but just in case, the public is watching, please know it's a very, very small number when you look statistically at, being one of the largest employers in Lee County. Our number is really, really low.
Yeah, except when you become that.
Right. Oh, absolutely. No, I agree with you. I'm just saying the good news is it's not a lot.
No, I'm very happy to see this.
Yep.
I think it's going to give us an objectivity that perhaps was lacking in the past when it was one set of eyes, start to finish. I think this is a great, great step forward. And, I'll say to the employees out there, it's a good thing.
Thank you.
Great, thank you. Okay, I think we're ready to move on. Attorney Bruno.
The only thing I would like, Madam Chair, is board directive to move proposed policy 5.331 to the formal rulemaking process. If I can get a consensus.
Okay. Board members? And it is unanimous, 7-0.
Thank you, Madam Chair.
Also, just like to thank Attorney DePay Bruno for her leadership relative to getting us to this point today. I think that really helped us to get to this place in a positive way, so I want to publicly thank her for that. I also want to let any board members know that anywhere from Mr. Hudak to Mr. Brown, anybody is always available if you think of something or as you review again and you have questions. What we want is what you guys talk about, and that's transparency and making sure everybody understands. So if the need arises, please know that we are here to serve and to answer any questions relative to our manuals.
Thank you very much. That's very important. Okay.
Thank you. The proposed policy 5.331, whistleblowers protection policy. Again, this policy is being brought forth by the same team, Dr. Atkins, Dr. Pruitt, Mr. Brown, Mr. Rothenberg, and Attorney Williams. And we're going to go through it just like we did the last one. Next slide, please. Thank you. Section 1.1 through 5, general purpose, establishes the procedures. This policy is not to be used by employees to protest. It is not to be used to protest evaluations or disagreements with management. We still expect employees to abide by the decisions of management. This policy is to protect employees for their good faith reporting. It is to provide a fair process for employees to seek relief. And there are certain things that the employee is expected to report upon, such as waste, fraud, and abuse, for example. Any violations of statute, any violations of board policy. Section 6 of this policy just discusses the definitions as defined by the statute. Section 7 through 8 specifically says that if an employee does report, there is no adverse action, and there will be no interference in the ability to share information. Section 9 of this policy discusses the hotline. As the board is aware, we are in the process of securing the hotline for employees to be able to call in. Once those calls are taken, then if it is a waste, fraud, and abuse call, it would be transferred to the internal auditor. With the legal services, we'll make a determination if it's legally sufficient to move forward and whether or not there will be an internal or an external investigation. If it is a human resource issue, then it will be turned over to human resources. Anonymous complaints can be made, but must provide sufficient collaboration. However, I do want employees to understand that whistleblower protection does not come into play if it is an anonymous tip. You must have a written statement signed to be able to have whistleblower protection. Section 10 to 11 discusses that there will be no retaliation, discipline, or reprisal for anyone exercising their whistleblower protections or providing tips or information. Section 12 discusses suspected retaliation. If an employee feels that they've been retaliated, they need to file a written complaint within 30 days. If the complaint is with regards to the superintendent, the school board attorney, or the internal auditor, that must be given to the chairman of the board. If it is to the school board member, then an external investigation will have to review it. Section 13 discusses that any of these whistleblower complaints must be done in good faith. Knowingly making a false allegation will be subject to disciplinary action. Section 14 through 15 talks about the public records requirement with regards to investigations, and also includes that the hotline will provide a report to the board on a monthly basis. Are there any questions on the whistleblower protection policy?
Ms. Morgan?
Section 5. Regarding expectations of employees. I'm just curious about why that's in the whistleblower policy as opposed to in a policy with respect to expectations for employee conduct.
The whistleblower policy specifically pretty much mimics the statute, and that is in the statute.
I know, but why is it in this particular policy and not in, and I apologize because I didn't go through the policies with respect to employment, but I would think that this really is an expectation of all employees and belongs with statute or not, belongs in a different policy.
Well, I think it could be added to, if we want to put it into the employee handbook. I don't know if Dr. Pruitt wants to address that, but in terms of it being in this particular policy, I would say that it does belong in this particular policy because it is part of the whistleblower protection statute. That is the language from the statute.
That's what she said.
It's part of the statute.
Oh,
Yes.
this particular,
Yes.
okay, all right, that answers that question. Thank you. And I was going to, section 8. And the note I made to myself is that it doesn't include, if employees are not, does not, if the definition of employees doesn't include school board members, then are school board members excluded from this prohibition?
We can add school board members to that. That makes sense.
Thank you. Those are my questions.
Thank you very much, Ms. Morgan. Ms. Gittens, then Ms. Vaughn.
Okay, my question is on section 9, where we talk about anonymous, and I'm just a little confused with it. On line 107, it says, or 109, the hotline is available for any person both identified and anonymous wishing to report. And then B, it talks about, C, anonymous complaints or reports may be made. However, such complaints must provide sufficient corroborating evidence. I'm just a little confused about that, because when you said they cannot be anonymous, but this says they can be, but they have to provide information, and
So we had the team had a lot of discussion about that. And basically, the statute requires that you identify yourself to trigger whistleblower protection. You need to be able to write the statement, and you need to sign your name so they know who it is. But at the same token, we wanted employees to feel free that they can also call if they did not want to identify themselves, but they do need to provide enough information that collaborates so that we can look into it.
Okay, so in other words, as an employee, one can call in and say, there is this issue in my estimation, and not say anything else about it. If they want to go further and want to be protected, then they would have to fill out the paperwork.
Correct.
So, in other words, if one of my fellow employees wanted to call in and say, I see this happening to so-and-so, they can do that anonymously, but then the person that it's about, if they want to continue, have to sign the paperwork, correct?
To get the whistleblower protection, yes.
Okay.
But I will caution that, you can have an anonymous person call and give information, but if there's not enough information for it to trigger an investigation, just because you call does not necessarily mean that it's legally sufficient to do anything with it.
No, and I understand that, but I can see where it would be if there is a blanket statement that says you cannot call anonymously. That's not exactly correct, and some people will not call because they will feel, I can't not call and say my name. So when we're educating the staff about this, I think that needs to be very clear that there are steps involved, and that an individual with collaborating information can indeed call anonymously.
Yes, ma'am.
Okay, thank you.
Ms. Vaughn.
I actually had a question on that same 9C. Mine's a little bit different focus. All right, so we already said, as in the last sentence in 9C, as anonymous callers are not identified, they cannot be afforded whistleblower protection. However, let's do this scenario. Let's say that what is reported on the hotline is warranted for further investigation, and the person who originally called in has even more information to share, and that person decides, okay, I feel more confident now, can that person then give more information, identify himself or herself, and receive that protection?
Yes.
Should that be clarified?
So the policy is pretty clear in terms of when the protection is, becomes in effect. So what you're saying is that you want some clarity that if you start off anonymously, but then at some point you want to identify yourself, you can still trigger the whistleblower protection?
Exactly, because initially people may be frightened of retaliation on many levels, and so they may call in, and then they realize this is being taken seriously, and I do have a little bit more that I could share, and they feel more confident because it's been taken seriously. Can they trigger whistleblower protection by then identifying themselves? I don't see that that's clear in this, and I see it as a possible scenario.
I think a sentence could just be added that says if the person then decides to identify themselves, then the whistleblower protection can be triggered. I don't know if any of the team members who are here have any objection to that.
Can I just ask a question on that same thing? How, if they're anonymous and they do it, how would they even be informed that it has been accepted and the process has begun?
That's the risk you take if you're doing it anonymously. I mean, we had a lot of discussion about that because there was some discussion to just remove anonymous completely because of these issues. But we wanted to make sure that employees could call and feel comfortable to leave a tip and provide collaborative information, so at least, we can look into it. I think.
And I totally understand that and agree with that. I think it's on Ms. Vaughn's comment of adding something about being able to go and come back and say that now they do want to. I don't think there's an ability to do that, because if you're anonymous, you are anonymous and you're not going to get an answer back. So I mean, I think it's fine.
I think what she's saying, though, is if you start off anonymously and then at some point you decide to provide information, then you're just kind of triggering, this policy.
Yeah.
Yes.
Vaughn. Well, in response to Ms. Gittens, you're probably right on how would they just find out, but I'm assuming that if you're anonymous, you get a code number. Wouldn't you get some? You don't get
There's no
anything?
code. There's no code number. You call into the hotline and you tell them.
So there'd be no way to identify yourself if you call again to add more?
Correct.
I don't mean your phone number, but I mean a special password or something.
No.
Okay, well, I was thinking that might be the case, that they get a special password so that they can call back and say, I have more information.
It's almost like a new tip.
Okay, the other scenario is when you have a whistleblower and it's a serious allegation, what happens? The people that may be harmed, they want to know who that whistleblower is, right?
Well, that's the whole purpose of this.
But then what if the anonymity is blown because somebody somehow gets it figured out?
Well,
I'm just worried that the anonymity, if it's really something serious, very serious, that's going to hurt people, hurt their livelihood or whatever, might be blown at some point, and then that person will not be protected. I would just like to see some way that person who called, I mean, how could they even call in then and say, hey, I called on January 7th, and I'm that same person again. I'd like to add extra information and, give my identity. It might be somebody, not the same person. or-
Ms. Vaughn, let me say this. First and foremost, we know that pretty much everything that we did was public records, right?
Yeah.
So that's the first thing. Now, the statute does provide us with some confidentiality during investigations. I think there needs to be a little faith in the process, because this is a new process that we're starting. If a call comes in for waste, fraud, and abuse, it's going to go to the internal auditor, and legal services will make a determination whether or not it's going to be investigated. So I would have faith in that process that it's going to work. Now, if it's a human resource issue, it's going to go through their process, which we've already updated. So I think we probably need to have a little faith in the process. I don't think that there's going to be any violations of the whistleblower protection. I think that everything will work out well. There's really nothing that we can put in here that basically says that, if the identity is blown. I mean, those are speculations. Those are things that's hard to put into a policy. However, if there's retaliation, if there's discipline, if there's reprisal, then of course there's actions that can be taken, and that's in the policy.
Okay. I trust your judgment on it. I just worry that if there are huge issues that come up with, let's say, fraud, that people that may be hurt with that will be very interested in narrowing down who that whistleblower might have been. So, and anyway, that's my opinion, but I understand what you're saying legally. That's it.
Ms. Patrica?
So my only question here is on 12B, specifically an employee who takes adverse personnel action or retaliates against someone who reported a concern in good faith is subject to discipline up to and including termination of employment. What happens if a school board member is found to have engaged in retaliation through an external investigator? There's no consequence here for that.
Well, for school board members, it's always the Commission on Ethics.
Right, so can we put that in there? Like automatic referral to, but if we have an external investigation that finds retaliation, I think that automatic referral to the Commission on Ethics is appropriate.
Well, if we look at 12, not subsection B, but 12 also talks about that there can also be an external investigation for a school board member. Is that what you're referring to?
Yeah, but if that external investigation finds that we retaliated, any one of us retaliated, there are no consequences in here.
So you want to add a sentence that it will be referred to the Commission on Ethics?
Correct.
Ms. Patrica, are you finished?
I'm done, sorry.
Thank you. Mrs. Giovanelli?
So if a student has reports or files, a whistleblower, or they call in on the hotline, let's just say, how is that going to work? Because, you could have, potentially could have students calling in about being bullied and that kind of thing. So how I don't see much in here about students calling in.
Well, this whistleblower protection policy is for employees.
I know.
So,
That doesn't mean students won't do it.
yeah, students may call, and I guess when that happens, it'll go to academic services or to the appropriate person. But this is specifically for employees.
I understand. I just know.
But you're right, they probably will call, and we'll refer them to the appropriate department.
Okay. And then, okay, so what about written complaints that come in and regarding whistleblower status? It could be, they would have their information there. how is that processed differently than calling on the hotline?
It's not going to be processed differently. If it's waste, fraud, and abuse, it's still going to go to the internal auditor, and if it's dealing with human resources, it will go to human resources. So it can come in through the hotline, it can come in via email, however it comes in, it's the same process.
Okay. So, and then back to what Ms. Patrica was stating about the Ethics Commission is the one that, or law enforcement is the one that investigations would be over elected official. So I don't know that our policy has the power to even do anything to an elected official. So I don't understand why our policy would, and not only that, but the board would need to have to do that as a board, not as an individual, and you can't investigate an elected official because that's illegal. So, or without the board giving that an approval. So how does that play out?
So I think this is going to have to be a discussion that I'm going to defer to the board for guidance as to what language you do or do not want to include in this policy.
Ms. Jordan?
I just think that some of this is getting confused with the hotline versus the whistleblower. This is whistleblower, not the hotline.
Good point.
And I think that's where there's a little bit of confusion of who can call and who cannot call, anonymous or non-anonymous.
Good point.
Ms. Gittens?
I tend to believe that there is kind of this separation of us as elected officials, because there are statutes and laws and all of that that govern us. So I would like to ask Mr. Bruno to maybe look into a comparison of other districts that have anything like this, that include the verbiage about the board. I really think that we have a different standard, and we have legalities that we have to follow and that people have to follow. And I'm not sure about what they are. Does that make sense here, what I'm asking?
So the issue that was raised is if an employee feels that they have been retaliated against by a board member, what can be done? That was the issue that was raised.
By a board member, though.
By a board member. And because the policy does specifically say what would happen to an employer, but the issue was, what can we do if it is a board member that is doing the retaliation? Do you want a sentence in there that says, if it is a board member found by the majority of the board, that a call to the Commission on Ethics? And this goes back to the ethics and education policy that you guys were discussing before. I mean, this is the same discussion that we had before. Do you want to include that in this policy, or do you not want to include that in this policy?
Well, to me, the question is if that retaliation is a board member against a board member or a board member against an employee, that sets up a whole different thing. And a board member against a board member is a different avenue altogether, and there are things in place to cover that.
I think the question was, if there is an employee that feels that a board member has retaliated against them, what do you want to include a sentence in there that says that it will be referred to the Commission on Ethics?
No, and that clarifies it. I wasn't sure if it was, who the two parties were.
Board member to board member is a completely different
Exactly.
area.
Okay. Thank you.
So I do need some guidance from the board on that. Do you want to include that sentence or no?
Yes, I would say yes.
I think so.
So
6-1.
I think it's
6-2. Melissa
5 to
and
2.
Ms.
5 to
Vaughn
2.
said
I'm
no.
sorry. Okay, I'm sorry, 6-2. I was getting the
Can you repeat
6 to
the
2.
Okay,
sentence?
so just to be clear, the question that I have, do you want to include a sentence that says, if a board member has retaliated against an employee, that will be referred to the Commission on Ethics?
Okay. 5-2.
So we will include a sentence in section 12, and we'll create it a 12C that adds that language to that.
Who exactly would be responsible for doing the reporting? Because I know that, I don't believe that we should be above anyone. Like, I don't have the right to go harass Dr. Spiro or Andy Brown or anyone like that. But who is that person that's going to do the reporting of that?
So there is, part of the policy is the external investigation on the board. So whoever's making that external investigation, if they feel that there's something that has happened.
So it would be
And it has
our
to be proven.
employer,
Yeah.
our employee would be reporting us.
No, your board attorney will not be reporting that.
No, the internal
Say that's okay.
auditor
No.
though is our employee as well.
Well, it will be an external.
Okay, gotcha, thank you.
It would have to be proven.
We'll have to go through the investigation process.
Perfect, thank you.
Thank you.
I have a quick question.
Yes, Ms. Gittens.
On 13 about, providing, using good faith and providing truthful information, basically, what did I miss? What is is there a consequence of that is what I'm asking?
If it's not in good faith, it can be disciplinary. It has to be a good faith report. You can't harass people,
Right,
make up stories.
right. And I think that's what you just said, in the way you said it, is the type of verbiage we need when we're telling employees about this, as opposed to legalese, terminology. In other words, employees, what this means is if you abuse this and say something wrong, you can be disciplined, period.
Thank you, Ms. Gittens. Mrs. Giovanelli.
So I would agree with this, actually, if the language is per the statute. So what does the statute say regarding that?
Which part?
About a board member and adding that to this?
With regard to the Commission on Ethics part, the statute does not address specific issues with regards to board members. It's a general employee, public employee whistleblower statute.
Okay.
So we're adding that language.
And so something that Ms. Gittens just mentioned, what I thought was also important, was the fact that what happens to an employee if they file, they want whistleblower status, and it's not factual, their complaint was unfounded, and now that is, that is an issue. So that needs to be very clear and defined, because how that's been handled in the past has been nothing. So nothing's happened. So explain that to me, how that would work.
So it requires a good faith. So if you think something has happened, and for some reason after the investigation it did not happen, but you really thought it happened and was good faith, then nothing is going to happen to you. If you made it up and you falsified or you committed fraud, well, that's a completely different story.
Okay, but then who has the authority to, what happens to the employee that filed a whistleblower complaint against a board member for thinking that they did something retaliatory, and that becomes not true? I mean, we've had that happen twice on this board particularly. So how do we address that employee? I think that's the question.
So let me digest this question a little bit. Ms. Giovanelli, your question is whether or not if an employee files and requests whistleblower protection and files a complaint against a board member.
Yep.
Okay. I'm going to have to digest that. The way that the process is supposed to work if the employee filed the complaint in good faith, thinking that there was something that really happened, then nothing's going to happen to that employee. If the employee filed something that was fraudulent or false, then the employee could be subject to disciplinary measures. And it would go through the entire process as we have laid out in our first policy with regards to discipline and investigations.
Okay, so when it becomes unfounded, then who's the responsibility to, obviously it's the superintendent's responsibility to deal with his employee. So how is that addressed? I mean,
I think if a board member feels like something like that has happened, they do need to address it with the superintendent. And if you want to talk to the school board attorney, and between the two of us, we can perhaps provide you more guidance.
well, I think it's something that probably should not be out of the sunshine.
No, I think this is a staff issue, because what you're saying is that how is the particular employee going to be addressed? So I think this is, because the employee is under the purview of the superintendent.
Yes.
So a complaint is made to the superintendent, and he will take a look at that. And I had suggested if you want the school board attorney to also be part of the conversation, but I'm not discussing specifically with the board member to be involved in that particular conversation, and then the superintendent can come back to the board with a recommendation.
Yes, okay. Thank you.
Thank you. Ms. Vaughn?
Well, I'm just going to reiterate that, yes, it has happened on this board, and I know for a fact, because I was one of the people harassed for something that was semi-fabricated. So it is an issue, and it was never dealt with.
Yeah, so, I mean, well, that's
An
my
issue.
point.
And it's something we need to keep in
You want to hold school board
mind.
members accountable, but we have to have, the accountability works both ways.
Okay, so I will say that in the earlier policy with discipline and investigation, it is very clear that employees do not investigate school board members. If an investigation is needed for a school board member, it will be it will be through law enforcement, government agency, or something of that kind, the Commission on Ethics or what have you. If a school board member feels that they have been retaliated against or there's some type of reprisal, I will go ahead and reiterate that this becomes a staff issue, which Dr. Atkins, and if you would like my involvement, we can discuss and then come back to the board with a recommendation.
Right, because I think we need to be really clear, board members are not employees of the district.
Understood. But I do think that the prior policy, I think, makes that clear, that employees do not investigate board members.
Right.
And thus, the external investigation requirement in this of board members who are accused of retaliating, right?
Right.
Okay.
So is there an action that we need to take? Because this is well-worn territory that we've been over, and we have disagreement even among the board. But it seems like we continue to come back to this. So I just need to know from the board, is there action that we need to take? Because I've taken the action that I felt appropriate.
Ms. Vaughn?
Well, I think to respond to Dr. Atkins, that's because it was never, at least in my view, satisfactorily resolved. And I think we need to be very clear that it's been one of the issues with this board that board members have been known to work in tandem with others to cast dispersions on board members. So it's the elephant in the room. Here it is. And I don't know if just talking about it will solve the issue, or if we need something in writing. But I can tell you, as a person that had an employee file a complaint against me that was, as I said, unfounded and dismissed by ethics. And knowing the history of other board members helping employees to do these things, it's very troubling to me.
This is raising a lot of questions with regards to boardsmanship, with regards to ethics, with regards to retaliation. I don't know what the prior this is before my time.
Right, it was.
So I don't know what the prior recommendation was. I don't know. But I'm not sure, Madam Chair.
Well, I was just going to ask is this relevant to our review of this whistleblower policy at this point? Or is that something that needs to be resolved between the board members and the superintendent in another forum?
Quite honestly, Madam Chair, I don't know what else this superintendent can do. We've gone through all kinds of training, discussion, we've changed our processes, all this stuff, worked very, very hard, but if it's still an issue, it's still an issue.
Yes, Ms. Patrica.
And that's unfortunate. I mean, if...
And I understand. Okay, so Mrs. Patrica and then Mrs. Gittens.
I agree with you. I think that this is a difficult conversation. How much does it have to do with the policy? But it does continue to come up, and people continue to allege that board members are acting in concert with staff members. And I think the purpose of the policy and the purpose of the discussion is, when we speak from this table, we have to speak from a place of fact and reality. And when we have investigations that show what happened, that's not really up to interpretation. And so, I'm happy to move on from here. I'm very comfortable with the way all of this has been handled, but I can't move on alone. The accusations continue to come at me, and this is over, this is done, this is behind us, and the accusations continue to come forward. So I don't know how to move forward without an agreement that we are, in fact, going to move forward.
Madam Chair, if I can call point of order, I think what the best way to move this forward is let's go through these policies. And again, I don't have enough information, honestly, to be able to guide the board in terms of whatever these backstories are as to what has happened and what the prior recommendations. So I can't provide the board with any advice at this time. So I would like to move forward with the policies, and then I will go ahead and take a look at this, and then I will come back to the board with a recommendation.
And I think that's an excellent solution. Thank you for that point of order. Okay, so shall we continue on with the policy review? We're at section 12.
I think there was, I just want to see I don't know if we did this already. Did we do a consensus on the language to add the, I think we did, it was a 5-2 decision.
Yes.
Is there anything else with regards to the policy?
Okay, seeing none, I think.
Gittens had her hand up.
And I understand there's like two different things here, but do we need to say anything in this policy that refers to, at this point, we refer to a different policy? In other words, this is not covering all the things with the board members type thing. So if there were some statement that's saying this is for employees and according to statute, whatever, any of these issues regarding board members will be whatever.
So for this policy, we just added language that if the board retaliates, we're going to refer to the Commission on Ethics. And the other policy, it's very clear that employees cannot investigate board members, only local government agencies can. So those two things are addressed. There is another issue that apparently needs to be resolved, but that's something that I think I'll have to have some time. I understand that there's still some frustration and there's some things that need to be aired out. I will think of a process and a way to do that, but we will address it. But I don't want to
thank you
address
for
it
that.
here. It's not part of the policy. This is something that has happened that needs to be addressed, but it's not part of this policy.
No, and I understand that, and I know we're moving on. The point is that when things are not finalized, that's why they continue to come up.
I understand.
Thank you very much. And if I might comment, over time, I have made some suggestions that sometimes issues involving personalities can be best resolved with mediation. And so maybe that is something for consideration, but I think that this is not the forum today for that. So can we move on?
Thank you, Madam Chair. At this point, I would like board directive, whether or not we want on the proposed board policy 5.331 to move forward to the formal rulemaking process
Yes.
with the amendment.
Okay, so we have 1, 2, 3, 4, 5.
The thing was, we still never clarified the reference if an employee makes a false allegation, and a false complaint against a board member. That's not been resolved, and that is part of that. That is
She
part of the
did answer
whistleblower.
that
I think we answered that.
twice or 3 times.
I don't think we did.
I think what Ms. Giovanelli is talking about is, should there be anything included in this process specifically with regards to a board member? And I will just,
Thank you, yes.
this whistleblower policy is for employees. I think that maybe the better avenue to address this and include any of those things maybe in the board manual with the process and procedures manual for the board. That may be a better place to put that in, what you're discussing. And I definitely am not going to forget about this conversation. We will address it, and we'll figure out some way to address staff retaliating against board members.
Right,
But I need
because-
an opportunity to do that.
Yeah, because it was in here regarding, if they make false allegations, and so how that is, needs to be addressed. And when it hasn't been addressed, then who's accountable?
Right.
That's the question.
I will say that 13A is pretty blanket statement that just talks about employee or a volunteer who knowingly or with reckless disregard provides false information. And I would say that it doesn't matter who that false information, someone within the system, they could be still subject to disciplinary process. So I would include board members in that, my reading of that language. However, I do know that, this is a very specific thing with regards to board members, and we need to flush this out a little bit more.
Well, that's fine, Madam Board Chair, but the thing is, we have been down this road before, and I think it's a matter of disagreement. And, in terms of I think that what was filed, there are people that believe that it was fair and it was just, and then other people who don't. And so, you can flip a quarter and figure it out maybe, but we have tried. And unfortunately, I think here we are a substantial period of time later, and we're still talking about this issue. That's unfortunate. I think we have tried multiple ways to try to get to the other side, and I, for one, had thought we had gotten there. But I'm wrong. And it's disappointing and disillusioning.
And I understand the point of order that you brought up, and I can't disagree with it, but I also can't disagree with Dr. Adkins, because we have got to move on.
Right.
And we're not doing that, because this will come up again in 3 months or 6 months or 9 months unless we agree to move on.
Madam Chair, may I recommend that, again, I want to move forward with the policies. We need to get this done. This has been sitting here for a long time, and your first instruction to me as your board attorney was to get this done. So I'm trying to move this forward. However, I also understand that we can't, it's going to be problematic for the governing team and the ability to govern if we don't resolve whatever these underlying problems are. So may I suggest that we have a workshop, and I'll think about it and talk to you about how we can do that to address some of these issues. Dr. Atkins, I don't know what has happened in the past. This is before my time, and I don't know what the recommendations are, but I hope you would give me an opportunity. Let me see what all of this is about, and then see what we can do to try to mend some fences and bring this to a final conclusion and move forward.
And I'm keeping a list of these issues so that we can add them to our continuation of our review of our policies and
Madam
procedures.
Chair, I would not want to have this delayed. I would like to probably get this addressed within the next week.
Okay, we'll make it happen. Thank you. Ms. Vaughn, then Mrs. Giovanelli.
Yeah, I'm just wanted to say, on my part, it wasn't specifically to rehash a particular incident that happened. However, we're discussing this policy, and we're using, we can do, when I was talking about something else, I was making up a scenario. But I think, I can't speak for Mrs. Giovanelli, but I can speak for myself. I am using something very real, and I'm not trying to, I realize what's done is done, but I think since we're revising and adding policies, that we might want to put safeguards in there that go beyond just somebody's word, that go specifically into policy. So this is why it was brought up, if people are not understanding why I had to, reiterate a little bit what Ms. Giovanelli said, because it's an illustration. And that's why I did thumbs down on this, because I don't think that kind of scenario is addressed.
So I'm going to respond to that, because I think the scenario is addressed, but I also see that there's some work to be done. That's why I'm kind of differentiating it. But if we look at line 157 in subsection 13, I'll read it. Anyone making a report as provided in this policy must act in good faith and have reasonable grounds for believing the information disclosed is a violation of law or an act as defined herein by protected disclosure. Thus, this policy does not immunize an employee, volunteer, or student from the consequences of his or her own actions, which actions do not constitute reasonable and good faith disclosure of the type of information described herein. Allegations that are not substantiated, yet are made in good faith, are not subject to corrective action. This includes any allegations made against school board members, superintendent, school board attorney, and internal auditor. So it is in there.
Yes, and it's clear.
Heard it 5 times.
Yes. Thank you.
Okay.
But what I took from our discussion was that it's in there and something has happened. What do we do next?
Thank you.
That's what I took from our discussion. But in terms of whether or not there is some language, the language is in there. It was added in there.
Thank you, Attorney Bruno. Mrs. Giovanelli, did you still have a comment?
Yes, so I love the whistleblower policy and the ethics aspect. So, and that's why I've agreed, I agree with everything. The investigations in the past with the new policy and procedure, I think will be more effective and not, some of the investigations in the past have proven to be, the outcome is, it's swayed. The outcome is what they want it to be instead of it's not factual, and they're alleged. And that's the problem, is nobody comes and says, especially with this investigation that we're talking about, mine, let's just be real. There's a lot of fabrications that are in there for a selected outcome, and that is the problem, is there's a lot of, false allegations within an investigation. So hopefully with the new process and procedure, that the due process will be done correctly. And that is the issue here. So I feel confident that with the new policy that it will be a more factual outcome, and because instead of an opinionated outcome and curtailed for a certain outcome that they want. So that's the issue. So I'm hopeful that with the new process that it'll be a better due process all the way around. So that's the issue. But second is you're correct. Once it's been violated, what happens after that? Who has the authority? The situation has just ended at that. Nothing's happened. So, you know, the only one that can hold any employee accountable is the superintendent. The only thing that we can do is hold the superintendent accountable. So that is where it really ends. You know, the law protects elected officials. So you can't investigate an elected official without telling them. So, and that is the situation with me, actually, and Mrs. Vaughn. There was an investigation
Point of
being
order,
run.
I thought we were going to
So-
address this at a workshop, and we were going to move on with the policies.
What happens when an employee breaks his policy?
Right, and this
Madam
is
Chair, I was,
another conversation, so
Asked and answered.
Ms. Patrica's point of order is well taken, and we need to move on. Thank you.
so
Attorney
at this
Bruno.
point, I just would like consensus, I believe, did I get consensus from the board about moving this to rulemaking? Okay.
Yes.
And what was the
It
number?
was, Ms. Giovanelli, I couldn't see your hand because there's a reflection.
Oh, yeah.
Were you
Yeah,
thumbs up?
yeah, we can move it.
6-1.
6-1.
I mean, it's still better than what we have, so.
The next policy, you have reviewed multiple times. It has not changed, just things removed from it because we did make the other three policies. So, you know, the first section is still with regards to the purpose. Section 2 is still with regards to the notice. 3 is about professional development. 4 defines covered individual. Prohibited acts are listed. Is there anything with regards to this particular policy?
Board members' comments on this, Ms. Jordan?
I'm sorry, I thought I had my note with me. Is this the one that had where the chair has to report publicly who has not taken the ethics?
That was taken out. You guys instructed,
That was out, okay,
Yeah.
thank you.
yes.
And thank you for this. This is well done.
Any questions on this one? This is one that I know that you guys are very familiar, the board is familiar with.
This is still the 1.30?
1.28.
Okay?
Okay.
Do you need a consensus?
I need a consensus to move 1.28 to the rulemaking, through the rulemaking
Okay,
process.
and board members? Okay, it's unanimous, thank you.
Okay. And at this time,
Yes, Ms. Vaughn?
There's a contextual problem with, I think, with the last sentence in, let's see, number 2, board internal auditors
which line,
will
Ms.
be,
Vaughn?
there's a word missing.
Which
Which
line?
line?
31,
Oh, 31.
can you take a look at that? Is there not a word missing?
Under which
Will be
one?
do something.
We're on
Are you?
1.28. I'm not seeing that in 31. If,
1.2.
I would say
Okay,
that
I'm on the wrong, I'm on 1.30, so,
if there's anything in that,
like typos and,
typos, those kind of things, if you would please email them to me,
Okay.
and that would be the best way to address those.
okay.
Substantive things, please advise now, but any grammatical typo things, we can clean that up.
Okay.
Thank you very much. Okay, Ms. Jordan?
The question that I had just asked, when I'm looking at this again, on,
Are you on 1.28?
yes, I am.
Okay.
Which line?
92, it says the school board chairman, chairperson shall publicly report the names of any school board members who failed to complete training on this policy prior to the first school board meeting after the first day of the school year for students.
What line?
92, it's page 3.
I apologize, that should have been stricken, because you had
I just-
instructed to
I
strike.
thought
Yeah, I had that
Thank you.
pulled as well.
Okay.
And then the last one, and I believe RSM was going to join us.
Are they joining us in person or by phone?
If I may, while we're getting them on the phone, Attorney Dupree Bruno, is there a reason why they are not here and they're on the phone instead?
That I can't answer, Ms. Patrica.
They should be connected.
Mr. Blondell?
Yes, hello, this is Matt Blondell with RSM. I also have Claire Ewing from RSM on the call.
Very much. We're going to go through Board Policy 1.30, the waste, fraud, and abuse. And then we'll go from there into an update on the SOW, as well as talk about the proposed audit committee. So this is the waste, fraud, and abuse policy 1.30. The first section discusses, defines abuse, fraud, and waste pursuant to the statute. Section 2 through 7 discusses the process, the hotline. Once a call comes in through the hotline for waste, fraud, and abuse, the auditor and legal will filter the complaints for legal sufficiency. Then a recommendation will be made whether or not to investigate. If an allegation is against a board member, superintendent, board attorney, board internal auditor, or the chief legal counsel, it will be reviewed by an independent investigator. Sections 8 through 11 discusses the completion of an investigation. Once the investigation is completed, a determination will be made and a conclusion reached and then shared with legal. They will also generate a report, and then the party will have 10 days to provide a written response to that report. Thereafter, it will be forwarded to legal services, and if discipline is required, to human resources, and of course, if any law enforcement involvement is required, that will also be handled. Any questions on this policy?
Okay. No hands. Oh, Ms. Patrica.
So I remember these complaints going to the OIG. At what point does the OIG get involved in this process?
Right now, they're not involved in this process. So if somebody makes a call to us for waste, fraud, and abuse, it's going to go to the internal auditor in collaboration with legal services, make a determination as to where it's going to go next.
Right, but what I understand is if we have a complaint that comes in, at least from an internal investigation perspective, if there's a belief at the outset that law enforcement should be involved, for example, the investigator will pick up the phone and say, hey, this is what's going on, I just want to give you a heads up, this might be coming your way. Shouldn't that be happening with the OIG when it comes to waste, fraud, and abuse as well? Shouldn't we be somehow indicating at some point to the state that this is?
So as this is something that will be discussed, so if a case comes in, it doesn't automatically go to the OIG, but as the cases come in, legal services and RSM are discussing it. From there, if it needs to go to anything external, that's when that will happen.
And so that doesn't need to be in the policy, that's just something that
Yeah, that's more, will be more of a process, yes.
And then, I guess that kind of leads to the next question. We were in a situation here before your time, Attorney Dupree Bruno, where we were receiving just a complaint after complaint after complaint after complaint being submitted directly to the OIG, and the OIG told us we had to investigate, and we said, no, we're not going to. Is there anything in this policy that deals with that kind of scenario where, like, at what point do false allegations add up to become just a complete and total drain on our resources?
So this is all things that will be discussed at that point when it gets to RSM, the internal auditor, with legal services to make a determination of how we move forward. So that's,
And, you know, if it's the 17th complaint by the same person that's unfounded, you just report to us that, you know, we decided not to pursue it?
this, again, these will be things that will be decided upon once it gets to that level between the internal auditor and legal services. If for some reason that needs to be reported to the board, because the board is going to get a report from the hotline on a monthly basis, so you'll be able to see. And if there's particular questions, the board can ask at that time. But these are judgment calls that will be made by legal services and RSM, the internal auditor.
Okay, thank you. Ms. Giovanelli?
One of the questions I have is, I know we have to report to the state or federal, depending on the violation or whatever. So at what point does that happen? At the end of the investigation, I mean, at the end of this, investigation and the findings, or at the point of the initial complaint comes in? So where is that at?
So a lot of this are factual judgment calls, case by case. You may get a complaint that comes in that's a couple of sentences that doesn't give you enough to do anything with. So as the process moves forward and we find out that this needs to be referred here, or this requires law enforcement or what have you, then the proper referrals will be made. But I can't tell you if it's going to start at the beginning or at the end of the investigation, because we just don't know where the facts will lead us.
Right. Okay. Thank you. Yes.
Okay. Go ahead and proceed, Attorney Bruno.
Are there any other questions with regards to this policy?
I don't see any hands.
If there are no questions, I would like directive from the board whether or not we want to move forward with 1.30 and the formal rulemaking process.
Okay. So, Ms. Jordan? I'm sorry. Okay. Mrs. Giovanelli, I can't see your, okay. It's unanimous, 7-0.
Can I make a comment?
Pardon?
Can I make a comment?
Yes, please.
Attorney Dupree-Bruno, this has been a concern of mine from the very beginning. I'm sure you've heard me repeat it. I am ironically very concerned about abuse for a waste, fraud, and abuse policy. So you and I will probably have more conversations about this. The other three, I'm kind of good, but this one is, I'm not seeing, I'm really concerned about the waste of resources. And I hear what you're saying about the upfront process, and maybe if you can talk me through that process, I'll feel better about it. But I know the man hours that have been wasted by just going down rabbit hole after rabbit hole. And I'd like to see this process protect against that, if that makes sense.
So I have a recommendation to the board that the board creates an audit committee. So if we can get the audit committee slides up, please.
Thank you.
So in the discussions with RSM, as well as with Kelly Letcher, we have been negotiating the SOW with RSM and addressing certain things that came up at the last workshop with regards to timeliness, with regards to communication, with regards to cost. During those discussions, one of the things that came up was the possibility of having an audit committee. Brevard County has something very similar to our process, and they have been using RSM for many, many years. I reached out to my counterpart there, Mr. Gibbs, with regards to how their process works and how they handle their audits. And I also did a little bit of research with the help of my assistant, Ms. Tortosa Ursley, with regards to what other districts are doing and how many other districts have and utilize an audit committee. I think it would be beneficial for this board to think about implementing an audit committee, because I think it will address, for example, Ms. Patrica's concerns in terms of the volume of false claims, if you will. It would also provide some direction as to what things, what are the priorities of the board in terms of audit, open the lines of communication, and almost have like a think tank with regards to audits. The purpose of the audit committee would be to advise the school board on the maintenance of a high level of accountability and fiscal responsibility, advise and guide the school board on the recommended changes that may be made by the internal auditor and audit findings. The selection of members of the audit committee, I'm recommending be members of the public, with each board member selecting one person to serve on that committee. However, based on my conversations with my counterpart as well as with the internal auditor, it is highly, highly recommended that those individuals have some type of finance background, because they need to be able to understand the language, understand the processes that go along with an audit. In addition, there are other members of the audit committee, to include a board member, of course, the internal auditor, the superintendent, the school board attorney, and the chief financial officer. The first meeting of the audit committee should be with the board, the full board, to discuss the priorities for the year. And then the audit committee will meet quarterly. In addition, the internal auditor, RSM, in the new SOW that will come before you, you'll see that they have additional communication with the board on an as-needed regular basis as well, to include their biweekly emails. And those dashboards will be a little bit more specific, so that the board is continuously apprised as to what's going on with the audits that they are conducting. The last meeting of the audit committee will be to provide a full report to the board of the yearly activities. So at this time, Madam Chair, I would request any questions, comments, or discussion. And I know that Mr. Blondell and Ms. Ewing are also on the phone to help answer any questions with regards to the proposed audit committee.
Thank you. Board members, questions, comments? Ms. Gittens and then Ms. Morgan.
Ms. Morgan can go first.
Ms. Morgan?
Yeah, I don't really have a question about the process, but I do have a question about evaluating the auditor, what role the audit committee would play in evaluating the auditor, and if the auditor is on the audit committee, how would that take place?
So with regards to the evaluation of the auditor, since the internal auditor now is an employee of the board, they will be evaluated the same way as the superintendent is and the school board attorney is. So that would be that evaluation. With regards to the auditor being on the audit committee, it would be my recommendation that the internal auditor not be a voting member of that committee, but be able to contribute information and guidance and provide reports.
Thank you. Mrs. Gittens?
As far as process with this, since it is a new committee for the board, then we would have to bring it forth in action meeting, correct?
Ms. Gittens, just repeat one more time. Bring
I
back to the
said, since this would be a new committee for the board, we can consensus or whatever today, but this needs to be brought forward to a hard vote in an action meeting?
Yes.
Is that correct?
Yes.
So I would like to suggest, after we've, discussed, that we do bring it for good of the order in our meeting next week to move forward with it rather than to wait any length of time. And if my other statement is that if we are going to have a liaison, I would like to put forth my name to be the board liaison for it.
Thank you, Mrs. Gittens. Ms. Patrica and then Ms. Vaughn.
So I think that audit committee is just a best practice, not just for school districts, but for fiscally responsible organizations, public and private. So I fully agree that we should create it. In terms of the 7 members, if we could agree to use the same sort of parameters that we used for board advisory committees, which is I would choose from 3 if I can find somebody qualified. You know, we would each choose from our district, and then of course 5 and 6 and 7 can choose from wherever. I would like to recommend that. And the other thing I was going to recommend is that whoever is the board liaison to finance advisory be the liaison to this as well. I think it makes sense to sort of keep finance together. And I think that's you, right, Ms. Gittens?
No, I'm not
I
on
thought you were finance advisory.
No, I'm not on any of those, no. I have
You're not a liaison?
I have CSI.
Okay. I'm sorry, I thought you were finance advisory. I swear to you, I did. And I thought I was encompassing your request in saying that.
I requested that, but I did not get it.
Okay. My bad.
And it actually may not be a bad idea to have a fresh pair of eyes.
And I would just like to say, I think we need to kind of spread it out.
No, I agree with you. I really, honest to God and truth, thought I was encompassing you in that. I really did. So I take that recommendation away, but I stick with my first recommendation. My bad.
Ms. Gittens, do you have a comment?
No, I'm fine.
Okay. Thank you. Okay. Mrs. Giovanelli.
I just think it's a great idea, so so I'm very supportive of it. My question would only be, where does the audit committee fall in with, is that kind of like a third, you know what I mean, a third group, really, third set of eyes? If you really think, if they bring it, if RSM brings that to the audit committee, that's like a third, right?
So I think this is, once the board decides that it does want to move forward with an audit committee, my recommendation, and I do agree with you that it will be a third set of eyes,
Okay.
my recommendation would be that the board liaison and the internal auditor, and I will be again in contact with my counterpart who has sent me some additional information to review to try to flush out a little bit more in terms of what the responsibilities will be and how the committee would function, and then we'll bring that back to the board.
Perfect. Thank you. Ms. Vaughn and then Ms. Jordan.
Yeah, I think it's too early to bring it to an action meeting. We have a lot of, this is a good outline, a good starting point, but my suggestion would be that each of us perhaps email Ms. Dupree-Bruno and, for instance, issues, should the liaison be, or should the school board liaison be somebody that's already either on ISOC or finance? Should we be selecting individuals that are not already serving on advisory boards or not? And those kinds of things. And then as we kind of flesh out our own ideas as a board, then those different ideas are brought forward.
So, Ms. Vaughn, my recommendation to the board would be that the board decide to create the committee,
Right.
and then we can flesh out all of the specifics. So at least we have a starting point. We know that the board wants to move forward with that, and that will allow us to come back to the board with some recommendations in terms of how to move the committee forward.
Okay, so what you're saying is that it's not too soon if we have the appetite to do this committee to vote to have it at an action meeting, but that would not include any of the details.
Right, we can vote, you can vote to have it at an action meeting, and then allow us some time to try to come back with some details and some specifics. Now, I would request, as we are trying to come back with the specifics, that we do have a board liaison to assist with that, so that, we have the board's voice and then when we come back with the recommendations to the board, it can vote on it.
Okay, and I'm listening to what you're saying, however the board decides on this, I would prefer to have details worked out so that when I vote, yes, let's have this committee, I have a clear idea of the makeup and some of the regulations or rules, protocols around the committee. That's just my preference. I'd be happy to do a consensus right now and say, yeah, let's move ahead with it. But it seems to me that most of the time, don't we usually have more details worked out before I just hate to vote for something when all that I know is, hey, it's going to be a committee and there's going to be community members and a board liaison. That's a little vague.
Your point is well taken, Ms. Vaughn. May I make a recommendation that we have a working group that can sit down and try to flush some of these specifics out and then come back to the board with that?
That's what I would prefer, or as we've done with some other things, just we all send our, either a working group or that we send our ideas to you, like, yes, it should be somebody who's already on an advisory committee, that's okay, or, those kinds of things for each of your skeleton outline items here. That's what I'm thinking.
So, Madam Chair, if I can get a consensus that the board does want to move forward with the audit committee, and then if I can get a consensus on getting a working group together so we can come back with some more specifics for the board.
Okay, then first, we'll take a vote on moving forward with the audit committee. So, and it is unanimous. And then the second part of this is, do we want to have a working group to iron out the details or to set the parameters for the committee before we vote on it?
Are we the working group?
Yeah, who's the working group?
Yeah. Because, I think that if it's our board, our committee, that we should be the working group. So I don't know what you mean.
It states in there, one of the things that the first meeting is to iron it all out, is
Right.
including the board.
It says first meeting is with the entire board and the committee to discuss the goals and objectives for the year.
But I think that before that, after it's kind of formulated, so in
And
other
that
words,
was-
the
yes.
working group,
And I think, Attorney Bruno, that was your recommendation, right?
For
That
the
we
first
form a
meeting, but
committee.
I think based on Ms. Fawn's comment, we have one step prior to that, which is to come back with some parameters as to how the board chooses who's going to be on the committee, how the board chooses the official liaison to the committee, et cetera. So,
Okay. Yes, and Ms. Patrica?
Can I suggest that a working group is a layer of bureaucracy that's the kind of stuff that drives me crazy with government? Can we just email you our preferences and you find areas of agreement?
I can do
And bring those
that.
forward, and then any areas that need discussion can be discussed at our next workshop or briefing or whatever, and we can hammer out those, and then boom, we have a committee.
I can do that, but I want the board to, I still would like to have one board member to work with, and I will also be working with the internal auditor.
Probably be either the chair or the vice chair, right? Pardon me? Should it not typically be the chair or the vice chair?
However the board decides.
Okay, so then we're going to take consensus on having the working group to gather the information, whether it be by email or in person. Yes, Ms. Giovanelli?
Maybe it should be the liaison that we decide who's going to be, to lead that with you. So I think that maybe we probably need to decide, my opinion would be, that would be the liaison that's going to continue that group, so.
Okay, so
That would be my thought.
I think that the opportunity for all of us to have input about parameters and the way we choose the committee members in the working group is what we're voting on now. I mean,
Right, but she said she wanted to
because
work
then,
no, that's,
She said she wanted to work with some one person in RSM.
Yes, okay. Okay.
And that would be initially.
Back it up
That will
then.
be initially, and then we'll be able to come back with some recommendations.
So I think the,
Okay, Attorney Bruno, then you said we're going to vote on the working group, which will not be every board member, but did you not ask every board member to send their
Every board member, send me
questions
your
and suggestions?
comments, questions, suggestions.
Yes.
I would prefer to have one board member to work with as well as the internal auditor.
Okay, thank you.
okay, but
So then do we need to choose the board member first before we vote on the work group?
That would be my recommendation if the board is inclined to have somebody volunteer to work with me on this.
Okay, so Ms. Gittens volunteered.
Okay, I know I was after Ms. Vaughn, and I have to say that I agree with what she says. As far as the information, I think it's too vague, and I would prefer to have more information pertaining to what this group is going to be taking care of. And if they are the eyes, some of it's on the presentation, but, well, it's not really on the presentation. So, I mean, are they going to be sitting there looking at all the cases that may come forward? So those people need to make sure that they're an unbiased set of eyes that are looking at those as well, especially with some that will come in 25 times. So you need to make sure that all that takes place. So I think that if all of us have our input into this, I would prefer that as well, and come back later. Even though we know we want this committee, I think it's better for us to have more information or detailed information.
Right, so I'm not asking for a vote on the specific responsibilities of the committee or what the committee is actually going to do. I want to have at least, I don't want it just to be me to come back with recommendations to the board. I would like to be able to work with RSM, and I would like to be able to, it doesn't matter to me which board member it is, but to have a board member, the auditor, myself, be able to discuss and flesh some of these things out so we can come back to the board and have the specifics in terms of what this committee will do and what our recommendations are, if that makes sense. So I just need a little bit of help to be able to get this all together so that we can come back to the board with our formal recommendations.
Thank you, Attorney Bruno, for that explanation. Ms. Vaughn?
So I would like to suggest kind of putting these two things that we've brought up together. Ms. Gittens has put forth her interest in being a liaison. Why don't we have, I'm suggesting Ms. Gittens work with Ms. Dupree Bruno, and then going along with what Ms. Patrica said, which is actually what I was saying before, that we can send everything in. Now, would that, though, be a sunshine violation if we sent them? That's my only concern, if we...
Emails? The emails you send to me?
No, but, so the emails come in to you, but if you're already working with a board member as well as RSM, and then that board member is reading all of our suggestions, are we okay with sunshine?
I was actually going to ask that.
I'm not going to disclose the emails to the board member.
Right, you would just compile a list.
I won't disclose. It will be a conversation between the internal auditor, who is staff, myself, who is staff, and one board member. So
Okay, but I thought that, all right.
I will have the information. I'll compile it, but I'm not disclosing
Right.
what this board member said or what that board member said or anything.
Okay, so it won't be a violation?
No.
Because the names of who sent what?
Right.
It'll just be...
It'll be just like data.
Got it. Okay, yeah. So that, to me, sounds like it's taking what you're saying, and it's taking what I believe, what I think, what Ms. Patrica said. So that's what I'm suggesting we do a consensus on.
Gary, got my thumbs up.
Okay, so we've got 1, 2, 3. Was yours a...
I'll live with it.
She's living with it, okay. And Mrs. Giovanelli, I didn't see your thumb. Okay. 6 affirmative, and 1 could live with it.
Thank you, Madam Chair.
Thank you.
With regards to the SOW, we are still in negotiations. We hope to have a final draft of the SOW, if not today, by tomorrow, so the board can review, and then it will come before the board on Tuesday at the briefing.
Ms. Fisher?
That's fine, thank you. And did you want to ask RSM if they have any comments about that?
Mr. Blundell, Ms. Ewing, do you have any comments to add?
No, this is great that you're moving forward. Very excited to work with you.
Very much. Ms. Gittens?
Okay, I'm just slightly confused. When we took the consensus, it was to have a board liaison. Did
Right,
we
that's you.
assign? Was that saying that I would be?
I think we all agree. Ms.
That she will be working with Ms.
Ms.
Bruno.
Dupree Bruno.
Okay, I wasn't sure about that. Thank you, and thank you for your confidence.
Thank you. Ms. Patrica?
RSM a question? Yes. RSM, this is Chris Patrica. I'm wondering at what point we would be able to expect to have you physically present at our meetings, please?
We are still in office closed situation. We have to get special approval. So if we know meeting ahead of time, I don't think we're going to get approval in time for Tuesday's meeting. But if we have enough advance notice, we have an approval process that we have to go through with our leaders to be able to go to client locations.
Appreciate that explanation. Thank you.
Thank you. Okay. Then, do you have anything else, Ms. Bruno?
I don't know if there's any other questions, but the only thing I would say is I think that the board has made some significant progress, and the governance team as a whole has made some significant progress in working together for the benefit of the district, the students, and the staff. And I do understand that there's a history, and I understand that things have happened in the past, but I would caution us to take steps backwards as we have been moving forward. I do understand that there's things that need to be addressed, and they will be addressed, but I really don't want anyone to go back and lose faith as to where in the leaps and bounds where this board where the board is now. I think that we're on the board is on a good footing, and we need to move forward in that direction, especially as the governance team.
Thank you. Okay. Ms. Gittens?
I just want to say publicly great thank you to Ms. Bruno for, she's just been on board since April and helping us get all of this process done and across the finish line. I think is really admirable. I'm very happy to see the process at this point. It's been literally almost exactly a year that we started this, and to see it to fruition, and with all of her hard work, I just want to make sure that we thank her for all the things that she has done to make sure we've gotten this across.
Thank you.
Thank you. I concur. Okay, at this time, next on the agenda is good of the order. We'll start with Mrs. Morgan.
I have nothing, thank you.
Ms. Vaughn.
Not at this time.
Ms. Gittens.
I have nothing, thank you.
Ms. Jordan.
I have none, thank you.
Ms. Patrica.
Thank you.
Ms. Giovanelli.
I'm done, thank you.
And I have nothing either. Okay, at this time, seeing no other business and seeing no objection, this workshop is concluded, and we will be back at 1 p.m. for the afternoon session.